As the committee well knows, there are numerous examples of these failures. The mistreatment and unjust removal of Native American ancestral remains from their resting places is just one of them. And for decades, the Native American Graves Protection and Repatriation Act of 1990, or Nagpra, has helped to heal the pain felt by generations through return and repatriation of these remains to their native communities. Nagpra's promise of ancestral homecoming has taken on a deeper meaning recently after the grim discovery of mass graves of Native children at government-run boarding schools in Canada, reopening old wounds and forcing the U.S. to face its own troubled legacy of Native boarding schools. As the Department of the Interior undertakes its federal Indian boarding school initiative to examine this legacy, it is my hope that as a nation we are truly on the path towards reconciliation and healing. Repatriating ancestral remains and cultural items is difficult and often painful work. Recognizing the significance of this work to Native communities, I would like to turn the floor over to Nagpra Greg to provide us with an opening to help us to set the tone for this important discussion. Ms. Gregg.
Aloha kakahiaka ya kako. I send you warmest regards from Hawaii and more specifically the island of Maui. Our iwi, our bones are sacred because in those iwi are the mana, the energy, the power, the very essence of a person long after their passing. And here on Maui lies the final resting place of perhaps the highest ranking line of chiefs, the Piilani line. Today, I present to you a mo'oku auhau, a genealogy of the Piilani line of chiefs, which begins at Kapela Li'io Ka'e, the sacred burial cave here at Iao. Oh, Maui, oh, Papa, Kani, oh. O ha ho kalulu kaupaka paka no na ia wahio ia o na kai ai aya o leila o kala kawa e hua kama no kapela li o ka kai no loko hauna geli o kawalu o lo e o ke kumaka ala neo o la i lo he a kalamaku o na kapua o pi lani wahi ne puka mai kamako kai o le pau o kaula he o kamala la valu no laila mai o ke o kalole ke ina nai hana o kala kawa Keli ina na ikai ko mauila kai ko iwai ka eha ken wan woli kawa kabailo he u he no he pa he nai mai kia ai ki mai na kai ya unei I mai na kabu na kamo alai.
Thank you so much, Napua. Nagpra became law on November 16th, 1990. For the first time, there was a process for Native communities to return their ancestral remains and cultural items back to their homelands from the shelves of museums and other repositories. When Congress was contemplating Nagpra, the Congressional Budget Office estimated that it would take 10 years to complete this work. Now, more than 30 years later, over 200,000 ancestral remains and approximately 2.5 million associated funerary items have been identified. But only about 42% of ancestral remains and 70% of cultural items have been repatriated. And so while progress is certainly being made, the journey continues for tens of thousands of ancestors and millions of cultural items to find their way home. And the promise of Nagpra continues. Before I turn to Vice Chair Murkowski, I'd like to extend my sincere welcome and aloha to Chair Hulu Lindsay of the Office of Hawaiian Affairs and to our entire panel of witnesses today. I look forward to your testimony and our discussion. Vice Chair Murkowski.
Chairman Schatz, Gunnar Shish, we appreciate you holding this very, very important oversight hearing today. As you have mentioned, it was back in 1990 that Congress passed Nagpra to establish a legal framework for the identification and the repatriation of human remains, funerary objects, sacred objects, and objects of cultural patrimony of Indian tribes and Native Hawaiian organizations. As the Association of American Indian Affairs states in a letter to Interior, they say, with Nagpra, Congress announced that continued possession of the deceased bodies of our ancestors and their burial belongings, sacred objects, and objects of cultural patrimony was legally and morally unsupportable. Nagpra recognizes that human remains of any ancestry must at all times be treated with dignity and with respect. It is past time that this committee exercises its oversight role to ensure that the tools Congress has given federal agencies under the law are being used to safeguard tribal communities from being locked out of decisions involving their own people and their sacred sites. You have referenced the connection with the very deeply troubling reports of children's remains that are being identified at former Native American boarding school sites. And while the protections afforded in Nagpra may not be applicable in every instance, I do hope that this committee can have a discussion on how Nagpra's already existing federal framework may be one of the many federal tools that we can choose to apply in order to correct a harmful period in federal Indian policy. In Alaska, Nagpra has played an important role in helping to repatriate human remains and funerary objects. Since Nagpra's enactment, tribal communities and institutions in Alaska have been awarded over $6.9 million in federal funds. These funds helped facilitate 155 consultation, documentation, and repatriation projects. The real-life impact of this federal investment means that from 70 museums and federal agencies located across the country, 1,843 Native American individuals were repatriated and returned home to their Alaska Native communities. But there is much more to be done. The work is not finished. There are still 406 Alaska Native individuals who remain housed in 26 museums or federal agencies, pending consultation and notification prior to repatriation. So I would hope to hear today from our federal witnesses about the status of those pending repatriations. And we absolutely need to be doing better across the country. According to the Interior Department's own statistics, only 21% of museums subject to Nagpra have repatriated all of the Native American human remains under their control. So I'm looking forward to hearing about the administration's objectives for any proposed changes to Nagpra's implementing regulations and how this committee can help ensure the success of this very important program. As part of any updates to the law, I expect the administration to consider the unique structure associated with Alaska's tribal communities. I want to welcome all of our panelists today, but particularly my friend, Dr. Rosita Worrell, president of Sea Alaska Heritage Institute. Dr. Worrell is a highly respected and accomplished academic, researcher, anthropologist, author. As they say, she does it all. She received her PhD and her MS in anthropology from Harvard University. She has a BA from Alaska Methodist University. She also holds an honorary Doctor of Science from the University of Alaska Anchorage. She has served on the Nagpra Review Committee for 13 years now, from 2000 to 2013, including a term as chair of the review committee. So she is deeply, deeply steeped in this, as she is on so many issues, most notably the preservation of Native languages, and seeks to encourage me daily in reminding me of my responsibility to help share with the preservation of those languages. As Anshawatki to you, Dr. Worrell, know that I give you my sincere appreciation and thank you. Thank you for being here.
Thank you, Vice Chair Murkowski. It gives me pleasure to introduce the remaining witnesses. First, we will have Joy Beasley, the Associate Director of Cultural Resources, Partnerships, and Science at the National Park Service. Then Dr. Ana Maria Ortiz, Director of the Natural Resources and Environment, the U.S. GAO. Then Carmen Hulu Lindsay, Chair of the Office of Hawaiian Affairs. And Dr. Valerie Grusing, Executive Director of the National Tribal Historic Preservation Officers Association. Ms. Beasley, please proceed with your testimony.
Chairman Schatz, Ranking Member Murkowski, and members of the committee, my name is Joy Beasley, and I'm the Associate Director for Cultural Resources, Partnerships, and Science for the National Park Service. Before I offer my oral statement, I just wanted to very quickly wish Senator Lujan a swift recovery. Thank you for the opportunity to appear before you today to present the Department of the Interior's views on implementation of the Native American Graves Protection and Repatriation Act of 1990, known as Nagpra. Nagpra recognized that human remains of any ancestry must at all times be treated with dignity and respect, and for over 30 years, Nagpra has required the respectful return of Native American ancestors and cultural items to lineal descendants, Indian tribes, and Native Hawaiian organizations. Implementation of Nagpra is assigned to the Secretary of the Interior, and since 1990, the National Nagpra program has been based in the National Park Service. The Secretary of the Interior has delegated Nagpra responsibilities to the National Park Service, including publishing notices in the Federal Register, administering grants to tribes and museums, receiving and recording inventory and summaries, and investigating failures to comply. Since 1990, the National Park Service has published almost 4,000 notices allowing for the repatriation of over 84,000 Native American ancestral remains and over 1.5 million funerary objects. Since 1994, we've awarded nearly $54 million in grant funds to museums, Indian tribes, and Native Hawaiian organizations for consultation and repatriation, and we've undertaken investigations that have resulted in many thousands of dollars in penalties. We also provide technical assistance to Indian tribes, Native Hawaiian organizations, museums, and federal agencies involved in repatriation or disposition. We provide direct training to over 2,000 participants annually, and we respond to thousands of individual inquiries by phone or email. The National Nagpra Program Manager also serves as the designated federal official for the Nagpra Review Committee, a federal advisory committee. The committee provides an annual report to Congress outlining progress made and any barriers encountered in implementing Nagpra. The most recent report for 2020 and 2021 was finalized by the advisory committee at the end of November, and the department is preparing it for transmittal to Congress. While there have been many successes in implementing Nagpra, the department is aware that more work needs to be done. Since the passage of Nagpra in 1990, less than half of the Native American ancestral remains in collections have been repatriated to their traditional caretakers. Over 117,000 Native American individuals are still in museum and federal agency collections, and 94% of those have not been culturally affiliated with any present-day Indian tribe or Native Hawaiian organization. Even in Alaska and Hawaii, where connections between ancestral remains and present-day people are well established, over 400 ancestors taken from Alaska and over 100 iwi kapuna taken from Hawaii are still in museum collections. The department is also aware that some collections subject to Nagpra remain unreported. Many federal agencies are still trying to locate extensive collections in non-federal repositories, and museums are continuing to discover unknown or unreported collections that are subject to Nagpra that should be returned to their traditional caretakers. The department's also aware that substantive updates to the Nagpra regulations are long overdue. We recently prepared a draft proposed rule and invited consultation with Indian tribes and Native Hawaiian organizations to discuss the proposal. The goal of the revisions is to simplify and improve the regulatory process for repatriation by streamlining existing regulatory requirements, shifting excessively burdensome and complicated procedures, and clarifying timelines. The department is currently working on incorporating the input we received during consultation and expects to publish a proposed rule for public comment in early 2022. In the revised regulations, the department is committed to emphasizing deference to Native American customs, traditions, and traditional knowledge wherever possible throughout the repatriation process. Chairman Schatz, Ranking Member Murkowski, and members of the committee, thank you for the opportunity to present the department's views on Nagpra implementation, and I'd be pleased to answer any questions you have.
Thank you, Director Beasley. Dr. Ana Maria Ortiz, please proceed.
Chairman Schatz, Vice Chairman McChrysky, and members of the committee, thank you for having me here today. Before I begin, I'd also like to extend GAO's wishes for Senator Lujan's recovery. During the creation and expansion of the United States, the federal government forcibly relocated countless Native Americans from their homelands, separating them from the bodies of their ancestors and from sacred objects central to their cultures. Over time, as archaeologists, developers, and others unearthed objects from indigenous cultures throughout the United States, human remains, funerary items, and other objects sacred to American Indians, Alaska Natives, and Native Hawaiians were disturbed, destroyed, stolen, or relocated to museums or private collections. The Native American Graves Protection and Repatriation Act of 1990, Nagpra, was an important step in addressing the hurtful and destructive impact of our country's development. In its broadest sense, Nagpra aims to promote greater understanding between federal agencies, museums, Indian tribes, including Alaska Native villages, and Native Hawaiian organizations. Specifically, Nagpra obligates museums and agencies to identify the Native American human remains and certain cultural resources in their holdings, and to work to establish their cultural affiliation as the first step in a process to help return these items to their traditional keepers. Nagpra also requires that federal agencies consult with appropriate tribes and Native Hawaiian organizations prior to excavating federal or tribal lands and upon any inadvertent discoveries. Lastly, Nagpra criminalizes the sale, purchase, and use for profit of any cultural items obtained knowingly in violation of the Act. My testimony today reviews major provisions of Nagpra and some of the progress that federal agencies have made since GAO last reviewed its implementation in 2010. For example, as a result of agencies' implementation of GAO's recommendations, Congress and the public can now access national data on museum inventories and specific items available for repatriation. My testimony also highlights recent GAO findings on issues central to Nagpra's implementation. First and foremost is the need for effective federal consultation with tribes. Museums and agencies that fail to consult effectively may have difficulty establishing the tribal affiliation of sacred items or repatriating culturally unidentifiable items to interested tribes and Native Hawaiian organizations. GAO also found that federal agencies encounter challenges in trying to protect Native American cultural resources on federal and tribal lands, such as resource constraints and competing agency priorities. Further agency progress in implementing GAO's recommendations from recent reports may help counter looting and trafficking of Native American cultural resources and could help with the repatriation of more than 116,000 remains of ancestors still held in museum and agency collections. In the 30 years since Nagpra's enactment, we have grown to appreciate the challenges federal agencies have faced in implementing the law, as well as the importance of implementing it effectively. Nagpra embodies the unique relationship the United States has with Native Americans. Its consultation requirements underscore the political sovereignty of tribal cultures that predate our nations. Its legal provisions to protect Native American cultural resources are consistent with the United States trust responsibility. Finally, in requiring repatriation of human remains, sacred objects, and objects of cultural patrimony to descendants and culturally affiliated tribes and Native Hawaiian organizations, Nagpra seeks to redress a small portion of the many wrongs that federal policies have caused over time. This concludes my oral statement. I welcome any questions you may have.
Thank you very much. Next, we are pleased to welcome from Hawaii, Carmen Hulu Lindsay, the Chair of the Office of Hawaiian Affairs.
Mahalo, Chair. I'd also like to wish Senator Lujan a speedy recovery. Aloha pihaia o ko pakahi apau. Much aloha to Chair Schatz, to Vice Chair Murkowski, and to the members of the Senate Committee on Indian Affairs. My name is Carmen Hulu Lindsay, and I am the elected trustee from the island of Maui and the chairperson of the Board of Trustees for the Office of Hawaiian Affairs. Our mission is to better the conditions of Native Hawaiians. I am here today to speak about the role the Native American Graves Protection and Repatriation Act, Nagpra, has had on Native Hawaiians. Iwi, or bones, and their care and protection holds an elevated status in our Hawaiian culture as they have for thousands of years. Iwi are our most cherished possession. The late Mary Kawena Kukui, a cultural icon and renowned Hawaiian scholar, has taught us the importance. We identify each other by literally the bone. Not only do the Iwi possess the spiritual power and essence of the individual, they are also our direct connection to our ancestors for communication and guidance. For we do not bury our dead. We kanu, or plant them back into the earth, from whence they came, to continue to nourish, heal, and guide future generations. This critical cycle has been disrupted due to the mass disinterment and desecration of our ancestors, especially in the last century of unfettered development in our island home. When Nagpra was enacted in 1990 here in Hawaii, the state of Hawaii passed human rights legislation to provide for the care, management, and protection of unmarked burial sites in the islands, of which there are tens of thousands, primarily comprised of our Native Hawaiian ancestors. This legislation, prompted by the deliberate and intentional excavation of the resting places of our ancestors, after which they would not only sit in boxes on museum shelves, but would also be sent all over the world for collection and study. Just over 30 years ago, the mass excavation of the sacred remains of over 1,100 men, women, children, and infants out of their final resting place occurred at Honokahua on my island home of Maui to build a large hotel resort. At the same time, hundreds of remains were being disinterred at another large resort in another area of Maui. Public outcry led to changes in our laws. While we continue to address ongoing disinterment and desecration of our ancestral burial sites in the islands, it was Nagpra which allowed Native Hawaiians to bring thousands of our ancestors home to be respectfully venerated and ceremoniously reburied. 10 years after the passage of Nagpra, almost 4,000 of our Native Hawaiian ancestors were repatriated out of our local museum on Oahu only. Thousands more Iwi were also repatriated from museums and institutions across the United States and internationally by using Nagpra as a model. Nagpra is living proof of what may be accomplished when individuals and organizations build a bridge founded on mutual respect and our shared humanity. Native Hawaiians are humbled and grateful to be of service to our beloved ancestors, knowing that but for them, we simply would not exist. In the increasingly contentious times now present in our world and in the greater story of humanity, caring for our ancestors guides, strengthens, and teaches us the enduring value of aloha, which embodies the concepts of love, compassion, and forgiveness. Ohe luna nui ke aluia. No task is too big when done together by all. OHA wants to help, and we offer the committee our written suggestions for future Nagpra amendments. We stand ready to assist as this August Senate committee may require. Ola na iwi, the bones live. Mahalo for this opportunity to testify.
Mahalo, Ms. Lindsay. Now we will turn to Dr. Valerie Gressing.
Mr. Chairman, Madam Vice Chair, and members of the committee, thank you for this opportunity. We're also keeping Senator Lujan in our thoughts and sending him well wishes for a full recovery. My name is Valerie Grusing, and I have the honor of serving as the Executive Director of the National Association of Tribal Historic Preservation Officers, NATHPO. I'm here today with our Repatriation Advisor, Dr. Timothy McEwen, who is also available to respond to questions. I'm speaking today from Silver Spring, Maryland, a DC suburb, and the ancestral homeland of the Piscataway and Nacotchtank peoples. As a descendant of European colonizers, I'm especially grateful and humbled for the opportunity to participate here and to do this work. When we're talking about healing the soul wound of our nation's first peoples, we have a responsibility to support and elevate Native voices in demanding basic human rights. When some of us aren't whole, none of us are whole. I've heard some of our members say that they try to walk into a room like their ancestors sent them. I'm doing that today from my own perspective, and I humbly offer a heartfelt apology for the systematic injustices and atrocities inflicted upon Native peoples, whether or not my own direct ancestors personally had a hand. I think this is important to say, and it's important to hear in processes of reconciliation. I offer the rest of my testimony in honor and service of those who were not present to tell their stories, those living and those who have walked on, as well as those yet to come, and with the hope that we are in a time of lasting transformational change. NATHPO is the only national organization devoted to supporting tribal historic preservation officers, THPOs. These tribal government officials protect culturally important places and revitalize the connections to cultural heritage that sustain the health and vitality of Native peoples. The repatriation of Native ancestors and objects of cultural patrimony is critically important to THPOs, who are frequently also the Nagpra representative for their tribe. After more than 3 decades of Nagpra, we again consider amendments to strengthen Indian tribes and Native Hawaiian organizations' ability to protect grave sites and reclaim their ancestors and objects, all basic human rights that somehow we're still fighting for. NATHPO has been deeply involved in these efforts, including a report in 2008, together with the Makah tribe, on federal compliance with NAGPRA and how to improve the process. GAO produced a report on this in 2010 and on the Smithsonian's repatriation efforts in 2011. And my and our chairman's predecessors testified before the House Natural Resources Committee in 2009 and before this committee in 2011. Unfortunately, the recommendations and report findings remain relevant today, and we submit our report for the record as a resource to support this administration's commitment to upholding the trust responsibility to tribes. We also submitted comments in response to DOI's boarding school initiative and draft proposed changes to the NAGPRA regulations, which we will submit for the record. We would like to specifically thank Secretary Holland and the Assistant Secretaries for ensuring that tribes are consulted as part of these initiatives. In our written testimony, we provide data on the implementation of NAGPRA's 3 sets of provisions. The law has not been ineffective, but has a long way to go. We recommend changes to definitions. We ask the committee to establish and fund an interagency task force to stop illegal trafficking of human remains and cultural items, and we ask the Senate to pass the STOP Act. We support redelegating program activities to the Office of the Assistant Secretary for Indian Affairs, as proposed in the 2020 Holland-Rokita bill to amend NAGPRA. We also request that the committee ask GAO to conduct 3 evaluations of federal agency compliance, of enforcement, investigations, and penalties, and of the NAGPRA grants program. Finally, it's my duty to talk about funding. THPOs receive dedicated federal funding that covers an average of one staff member, and they're not allowed to use that for their Nagpra duties. Nagpra funding is even more limited and is awarded competitively on a project basis. A system that makes tribes compete for limited funding for the most sacred and foundational restorative work is re-traumatizing. The time is now for the federal government to fulfill its promises, to fund and enforce agencies' consultation requirements, and to fund tribes so that they have a seat at the table, complete with the meal and utensils. Thank you again for this opportunity. We commend the committee for its intent to empower tribes in protecting Native places, grave sites, and reclaiming their ancestors.
Thank you, Dr. Grusing. And now we will turn to Dr. Rosita Worrell. Welcome to the committee, and thank you for making the long travel.
And if I may, our own Alaska Senator, beloved and respected Senator Murkowski, Anshawatki, Lady of the Land of the Deshiton clan. I am honored to have this opportunity to speak to you today. In honor of my ancestors and in accordance with our cultural protocols, may I tell you who I am in Tlingit. Tlingit chenach ya dekletsa kakahani achsayi. Shangu kedi kajak nachatsati. Kaudli yayi hit ayachat. Tlukachadi dachhunk ayachat. My Tlingit names are Yedeklitzak and Kahani. I am of the Shungukedi clan and the Eagle Moiety. I am from the House Lord from the Sun in Klukwan, Alaska. I am grandchild of the Tlukachadi clan. In English, I am known as Rosita Worrell, and I serve as president of the Sea Alaska Heritage Institute, and may I thank Senator Murkowski for that wonderful introduction. I was privileged to serve on the Nagpra Review Committee from 2000 to 2013, including serving as its chair. From my own work with Nagpra and from the multitude of voices I heard from Native Americans across the country and from Hawaiians during my 12-year tenure, I came to appreciate that Nagpra is one of the most significant legislative acts in our history. Congress recognized the significance of cultural property held by the museums and other entities. They understood the traumatic harm that had come from the expropriation of our sacred objects and our ancestral human remains from our homelands, and then the need to return them to their original owners and descendants. First, I would like to go on record supporting Representative Hadlin's proposed legislation, H.R. 8298, to amend Nagpra, to move the Enforcement Office to the Bureau of Indian Affairs, to increase civil monetary penalties for failure to follow the processes established by that act, and to protect confidential information. Secondly, I would like to offer a series of recommendations for your consideration. First, I would like to have it clarified that Alaska Native corporations are eligible to participate in the Native American Protections and Repatriation Act. And Madam Vice Chair, I have appended information on that background. I would also recommend and allow for the reburial of ancestral human remains at the site from which they were taken. Often we are told to sneak onto federal lands to rebury our ancestors from the original site from which they were taken. We do not believe that this is appropriate. Third, we would like to amend the Nagpra to require review committee findings in dispute as mandatory rather than advisory. Tribes go to a great deal of efforts and expense to bring the case before the committee, a committee comprised of scientists, museum professionals, and tribal members, without any guarantee that the committee's finding will be acted upon. 4, describe a discrete category of funding to support disputes. And then Increase Nagpra funding for tribes and museums. I know that this is a consistent recommendation of the review committee. Madam Vice Chair, I have also outlined a number of comments on the draft proposed rules. We have reviewed the National Association of Tribal Historic Preservation's office letter of September 10th, 2021, which I have appended to my testimony. We want to thank, first of all, the secretaries for their support, and we would like to go on record as supporting the tribal officer's position on the draft proposed rules. However, Madam Vice Chair, we do have a number of recommendations that we would like to submit for your recommendation in our written testimony. So, Ganoshish.
Ganoshish, Dr. Worrell. Until Chairman Schatz gets back, I will begin the questioning here. So, Dr. Worrell, let me begin with you. And first, I mentioned in my opening my appreciation for your work, not only in Alaska, but what you have done as the former chair on the Nagpra Review Committee for the department. As you know very well, implementation of Nagpra in Alaska can be challenging. It can be different than we see elsewhere in the country. We have unique tribal government and management structures that just make it different. We hear in this committee a lot about how it is different, where you may have multiple entities that play complementary roles in order to determine what the culturally appropriate next steps may be when we're dealing with sacred remains or funerary objects. So you've given a few recommendations already to the committee, but recognizing that because of Alaska's unique tribal history and the unique aspects, when we are talking about Nagpra's application to Alaska, you have indicated that ANCs should be eligible. If you can speak to that specifically and in the ways that tribes, ANCs, and nonprofits can work together so that Nagpra does work for Alaska. So just let's go a little Alaska specific if we may.
Thank you.
Go ahead and hit that button again.
Sorry about that. Thank you, Madam Chair. I will say thank you also for acknowledging that in the last 50 years, Alaska has developed different institutional arrangements than that of our lower 48 brothers and sisters. We have for-profit corporations. We have tribes, over 220 tribes. We also have regional tribal organizations that administer health and housing and other kind of services to our people. Native corporations were initially involved in the implementation of Nagpra. We were eligible for some 20 years. And then I believe it was in 2010 that the GAO did a study, and from that study, the recommendation came out to that the Park Service should look at our eligibility. And then we were later advised that ANCs and us, like Sea Alaska Heritage Institute, implementing the social, cultural, educational responsibilities of Alaska Native corporations, we were the ones that were implementing Nagpra. And so for some 20 years, we were very active in repatriation claims. As you know, collectors love Alaska Native material culture, and a lot of that was collected from all over the world. And so we started to do an inventory of all of our cultural objects and museums, and we finally quit when we reached almost 100,000. And we were busy with doing repatriation claims, and we were very surprised, when we were declared ineligible. We did a legal review, and we thought that we should have been declared eligible. But unfortunately, that was not the case. And in our region, repatriation claims came to all but a stop, except for our one regional tribe. So it's been a loss for us that we have not been able to continue this important work of seeking the returns of our sacred objects and our ancestors.
So I just want to make sure that we underscore that, because the role that the ANCs had been playing, as you point out now, for 2 decades,
Yes.
had really helped facilitate not only the inventory, but the ability to work on the repatriation efforts. And then once ANCs are deemed not eligible under this definition or through this read that GAO has provided and Interior through Parks has adopted, now all of a sudden you have ANCs that are left out of the picture. Now, it still means that your tribes can continue the efforts. The nonprofits can contribute the efforts for further repatriation. But you have limited the ability of an overlay of the tribal structure that has helped to facilitate much of the repatriation efforts to this point in time. So we're actually not only putting on pause, but we're not able to move forward because ANCs are now limited in this definitional approach.
Right.
Is that correct?
That is absolutely correct. But in addition to halting the repatriation process, what was also halted was dealing with the trauma of the removal of our ancestral remains, dealing with the removal of our sacred objects. So we were not able to continue the path that we had been on in terms of our cultural healing from that trauma. So it had both the administrative, operative kind of things, but it also had an impact on our culture.
Thank you. Thank you, Dr. Worrell.
Senator Cortez Masto.
Thank you, Mr. Chairman. I hope you can hear me okay. So appreciate the panel discussion today. You know, in Nevada, we've had a few cases of high profile and costly litigation under Nagpra. For example, in 2016, the Fallon-Shoshone tribe finally prevailed in a lengthy battle to repatriate remains that were over 10,000 years old that DNA testing had associated with native populations. So Ms. Beasley, let me start with you. One of the challenges that we have seen in Nevada is that there often has to be consultation with the BLM regarding repatriating items that are in university or museum possession. And what we're seeing, unfortunately, is there's a lengthy time frame within which the BLM consultation takes place. Is the administration taking steps to make agencies more responsive? Can you respond to that?
Thank you for your question. The Department of the Interior is aware of the inconsistencies with the way that the law is interpreted and applied across the United States, including among federal agencies. And we believe that the proposed regulatory changes will go a long ways towards clarifying the roles and responsibilities of federal agencies, as well as clarifying the timelines and the other requirements. So we're certainly aware of the issue, and we hope that the proposed regulations will address some of those challenges.
Thank you, and I appreciate your remarks. I also know the National Park Service just hired a full-time investigator to enhance oversight and compliance with Nagpra. Will you commit to working with our committee and providing members with annual updates on the actions of the new investigator, or if there are challenges or more resources that were needed to make sure we're providing the response that's necessary?
As you mentioned, we recently hired the first full-time investigator for the National Nagpra program, and we look forward to continuing to work with the committee on the implementation of the law.
Thank you. I appreciate that. This is for the panel members, and I think it was Dr. Gressing who touched on this, but one of the issues that has come up again and again is the lack of funding that has delayed efforts to really fully realize Nagpra goals. And at the end of fiscal year 2020, $50 million in grants had been issued since 1990, yet countless items still need to be repatriated. So to the panel, realistically, what type of funding commitment would be needed to finally see the goals of this law realized? Is anybody taking a look at that? Could you provide any input to Congress on how we can address that? And I'll open it up to the panel members if anybody wants to weigh in. All right.
This is Anna Marie Ortiz. I can speak to,
Go ahead.
I'm sorry, Dr. Grussing, did you want to say something?
No, go ahead.
I can speak to some of what happened in the wake of the GAO report in 2010. One of our recommendations was that agencies really figure out what they needed to do to implement the act properly and develop timelines for doing so. We heard from agencies at the time, including Fish and Wildlife Service, that it would take 28 years and millions of dollars to properly implement the act, to go through all of their collections. When agencies submitted their timelines, 28 years was much shorter timelines that they told us, yet it was still 8-10 years estimated. And in many cases, agencies estimated that it would cost hundreds of thousands or even millions more than they currently had appropriated to implement the act effectively.
Thank you. I appreciate that. Thank you again for this important discussion. I yield my time.
Thank you, Senator Cortez Masto. Senator Cantwell.
Thank you, Mr. Chairman, and thank you for holding this important hearing, and to Vice Chair Markowski. It's with 29 federally recognized tribes in the state of Washington, I guarantee you this issue has come up many times. We've had sacred sites impacted, and obviously the issues of tribal well-being and sovereignty. Just a few years ago, it seems like, the Ancient One, remains of the Ancient One were repatriated after several decades of investigation and research so that different tribes and bands of the Columbia Plateau could lay them to rest. I don't know how many people remember this debate, but clearly there was, even at that moment, lots of scientists and lots of differences of opinion about that. I also recall visiting the burial grounds in Port Angeles, Washington, where a major DOT project was going in to build a graving dock to help with repair of the Hood Canal Bridge. And literally the early stages of that development was the discovery of a 2,000-year-old village, Chichwitsin, that literally the construction and the building still went on for months. And the process failed us. The process did not resolve that issue. Now, maybe ultimately legal fights would have resolved it, but somehow we needed a process that would have resolved that instead of continuing the development on this site. Once it was discovered, we were building on top of a 2,000-year-old village, in a major discovery. So I do want to ask Dr. Gussing and Ms. Beasley what other protections, and to Dr. Worrell's point about making sure that there's a better process to resolving disputes, not just, maybe we'll have a hearing, maybe we won't have a hearing. And I get the framework of these entities that are currently involved, but these issues, particularly now that we have all sorts of different science involved, are way more complex than the process that we have today. And I think that, again, we had very major disputes about what we at that time referred to. Now I'm saying the Ancient One, but Kennewick Man, and then a lot of dispute, and then this other instance. Now, we also had a problem with one of our dams, so we had to draw down the water, and there we then exposed hundreds of burial sites all along the Columbia. And how did we protect them? And how did we use this authority to make sure, without identifying where they were? So I want to ask what specific changes Ms. Worrell or Ms. Beasley or Ms. Grusing would say that we need to implement that would help us on elevating the discussion and not bypassing it, and what to do to protect the locations from, public information, if that's so chosen. So whoever wants to start.
Dr. Worrell, would you like to go first?
Yeah, Dr. Worrell, go ahead, and then we'll go to our other witnesses.
Well, as we know, the disputes are just really lengthy and costly. And so I think we really need an assessment and coming up with some measures as how we could better work together on this. And consulting and informing tribal members immediately upon the discovery of any kind of human remains. That must remain in place. And I am concerned that there may be some changes in the resolution, in the procedures, the proposed rules that may alter that. We need to make sure that the tribes are there right away and that we have a say in any kind of inadvertent discoveries.
Yes, okay. In the Chichewisin case, the only avenue that the lower Skolem had, was to basically a lawsuit.
Yes.
And we kept saying this isn't going to end well for either side, so let's figure out a path to figure out what to do here. Ms. Beasley?
Thank you. So again, we believe that the proposed regulation changes will go a long way towards addressing some of the challenges with AGPRA with regard to streamlining the process, clarifying the roles and responsibilities, removing unnecessarily burdensome procedures, removing offensive language, and so forth. And we estimate that within a few years of enactment of the proposed rule changes, 90 to 95% of responsive collections will be able to move through the process. We certainly would be happy to work with the committee on technical assistance for any legislative changes that you might propose. I can tell you that some of the things that came up during consultation over the summer regarding the proposed rule that were concerns relate to the definition for Native American in the statute. Certainly concerns about protecting sensitive information, and there were a number of other sort of more minor technical amendments or legislative history that could be addressed, and we'd be pleased to work with the committee.
Thank you. I'm out of time, Mr. Chairman, but if Ms. Grusing either has a quick comment or can submit something for the record, I'd so appreciate it.
I would take a moment if that's okay. A critical issue here is the recognition of traditional knowledge and oral tradition as a valid form of knowing. And I wanted to note that in the case of the ancient one, the Ninth Circuit actually set really unfortunate precedent with their choice of some phrasing. And we would point to California Nagpra law as a better approach to recognizing this equally valid form of knowledge to the methods of Western science. And I think that this outdated colonial approach to disposition of ancestors is also re-traumatizing, and we can do better.
What was the language in that decision that was problematic?
Let's see. Oral tradition accounts are not specific, reliable, or relevant enough because they have been inevitably changed in context of transmission, because the traditions include myths that cannot be considered factual, because the value of such accounts is limited by concerns of authenticity, reliability, and accuracy, and because the record as a whole does not show where historical fact ends and mythic tale begins.
So we should throw out Greek myth too, or what? Anyway, we should work on this, Mr. Chairman. This is, some people would say, what, this is, who does this hearing relate to? There's lots of examples in the state of Washington where a better process would help us. And we appreciate this rich culture and the oral traditions. I feel so fortunate to have had some of them. I feel like we should even be doing more. But anyway, let's work on, I'm happy to work with the committee if the committee moves forward. Thank you.
Thank you very much, Senator Cantwell. Director Beasley, you testified that a greater percentage of collections have been repatriated to Hawaii and Alaska than have been completed in the lower 48. I don't want to get you in trouble by making you guess, but what accounts for the difference?
So the variation is largely a result of the relationship between cultural affiliation and geographical association under NAGPRA. So you're correct. 97% of collections.
Sorry, say that one in English.
Yes, sir. So it has to do with the relationship between cultural affiliation and geographical location. So if you consider that in many parts of the lower 48, Indian tribes were forcibly removed from their ancestral homelands to new locations. So they were, as Dr. Worrell so eloquently spoke to, effectively taken away from those physical locations. That is not so much the case in Alaska and Hawaii, where those cultural affiliations and geographical connections remain much more intact. And so
that theory would be relatively easy to test, because there are places in the lower 48 where tribes were not geographically displaced, and therefore they would have a higher rate of repatriation. Is that your experience?
I don't know if I could speak to the specifics of that. At this time, we could certainly look into that and report back to you. But revisions to the regulations that we're proposing would require museums and federal agencies to complete the regulatory process, and would require them to consider both cultural and geographical affiliation. And again, within a few years of finalizing the regulations, we would expect that 90 to 95% of collections could complete the process, and that would certainly be a much better statistic and more along the lines of what we see in Hawaii and in Alaska.
Got it. Okay, thank you. Chair Lindsay, thank you for taking the time. What qualifications do you think a Native Hawaiian organization should have in order to engage in the work under the Nagpra statute? Who gets, I don't want to use a legal term here, but who is legitimate in doing this work? How do you attain legitimacy? Is it ancestral knowledge? Is it lineage and genealogy? Is it geographic location? Is it study? Help me to understand how we determine who helps us to implement this law.
Thank you for that question, Senator. Under Nagpra, a Native Hawaiian organization, or an NHO, is defined as any organization that serves the interests of Native Hawaiians and has a primary and stated purpose provision of services to Native Hawaiians and has expertise in Native Hawaiian affairs. These NHOs are able to make claims and consult on repatriation matters. However, this definition does not require that these NHOs actually consist of only Native Hawaiians. This has been problematic in the past, as OHA has witnessed a museum and recreational clubs trying to claim NHO status. As indicated in our written testimony, this could be addressed by amending the NHO definition to require that NHOs have Native Hawaiians in substantive policy-making decisions.
Thank you very much. I'd like to work with you, Chair Lindsay, on this, and we'll work with our committee staff as well, because it also, the way the statute is written, it invites two people to set up a C3 and present themselves as representing Native people, and maybe they do, but there has to be a vetting process
Yes.
that has legitimacy both under statutory law, but maybe more meaningfully in the culture. And it's a tough thing, because you want to be as expansive and inclusive in the statute as possible, but if it allows, two people to claim to have the legitimacy that they may or may not have, it becomes very difficult, especially for the federal government, to sort out who's legit and who's not. And certainly not my job, and I wouldn't imagine Director Beasley wants that responsibility, but it is something we have to sort out as a community in consultation with Chair Lindsay and others who have a stake and deep knowledge in this area. Dr. Grusing, tribes are attempting to apply Nagpra to repatriate human remains found in the cemeteries at Indian boarding schools, including Carlisle Indian Industrial School in Pennsylvania. And I'm just wondering if you can explain how Nagpra would work in this context.
Thank you for that question, Mr. Chairman. We are so grateful for the light that's being shown on this issue after so long. I've actually got my orange on today in solidarity, because every child matters. NAGPRA has addressed this question in our comments on Secretary of the Interior's boarding school initiative, and we will submit that for the hearing record. To summarize, though, the excavation of Native American human remains from any federal lands requires compliance with NAGPRA. That means the federal agency must comply with lineal descendants and affiliated Indian tribes before excavation, including a plan of action. The excavation itself must comply with the Archaeological Resources Protection Act, and control of the remains would be as specified in Section 3 of NAGPRA. Our understanding is that the Carlisle Indian Industrial School is located on federal land. During the DOI boarding school consultations, we heard extensively from tribes that the Army is claiming exemption from NAGPRA requirements at this site, but we are not aware of any basis for that claim.
Thank you very much. Director Beasley, we all know that yesterday Interior announced the appointment of a full-time NAGPRA civil penalties investigator. Of course, that's good news, but the question is, what is the exact number of allegations related to NAGPRA compliance that NPS has received? Is there a backlog? Given that we haven't had a full-time investigator here, is this in response to an understanding that we're behind the eight ball? Where are we? And if you don't know the numbers off the top of your head, you can consider this a formal request to get us a status report on a backlog of complaints or investigations.
Thank you, Mr. Chairman. I don't have the exact numbers before me, but we will certainly follow up with you for the record on that matter. Hiring a full-time civil investigator was in recognition of the importance of that specific role and responsibility that we have. We were also looking ahead to, as we move forward with these proposed regulatory changes, we would anticipate an increase in civil penalty investigations. So it certainly, I think, is evidence of the degree to which we take that role and responsibility very seriously, and we'll certainly follow up with more specifics about kind of where we're at.
So just to put a fine point on it, there's two reasons to do this, and they're both legitimate. One is because it's important, and it's certainly worthy of a full-time person, or 10, right? That's number one. Number two could be that we're actually sitting on a backlog, and we can't even investigate them properly. And I'm not asking you to give me some number, but is there a backlog?
Again, I'm not sure I'm prepared to answer that question directly and specifically. We will follow up with you after the hearing.
That's fine. I'll let you off the hook here if, when you give me your answer for the record, I get a yes or a no to the is there a backlog question. Is that fair?
Fair enough.
Thank you. Vice Chair Murkowski.
Thank you, Mr. Chairman. This has been important discussion here this morning or this afternoon. I know that we're in a series of votes, so we're not going to probably have as much input from other colleagues on this, but I would like to think that there's going to be questions that are submitted for the record as well. Ms. Beasley, I want to ask about some of the things that I mentioned in my opening statement about the situation with regards to these pending actions on the individual remains. I indicated that, this is according to your department, there's still over 400 Native American individuals housed in 26 museum or federal agencies pending consultation and notification. Can you give me an update on where things stand with pending actions related to the 406 individual remains? What's the update?
Yes, ma'am. Thank you for your question. The National NAGPRA program has really detailed information on the status, and we'd be pleased to follow up with you after the hearing to provide you with that specific information. I can tell you that the National Park Service recently published notices for repatriation of Alaskan ancestors from museums in New Jersey, Michigan, and California. And I would also share that in 2020, we awarded an over $50,000 grant to the Alutiiq Museum in conjunction with the Tribal Coalition, specifically to support research and repatriation requests for the 20 or 30 plus museums across the country that are holding NAGPRA eligible Alutiiq ancestors and cultural objects.
So according, again, to the department, since Nagpra was enacted, apparently only 21% of museums subject to the act have resolved all Native American human remains that are under their control. So is it accurate then to say that less than 1/4 of all the museums subject to Nagpra are complying with the law, or is this an accurate way to interpret what that 21% means?
It's a great question. As I mentioned in my testimony, and as you note, after 30 plus years, less than half of the Native American ancestors that are in collections have been returned to their traditional caretakers, and largely due to identification of those ancestors as culturally unidentifiable. So museums and federal agencies still wield a significant amount of power in determining what will be repatriated. We hope that this imbalance can be corrected through the regulatory changes that we're proposing, and we hope that the Congress will support that effort by affirming in the hearing record that the purpose of Nagpra is repatriation.
Repatriation and returning their remains with the respect and dignity that should be afforded, absolutely. One final question for you, Director Beasley, and this is what we've heard from the native village of Chiniga. They've written to the department expressing some concern over some of the changes to Nagpra that Park Service is contemplating. They're worried that the effort to update and simplify notice procedures for discovery will result in less participation by impacted tribal communities. And I think an overall concern that you're giving greater discretion in the hands of federal officials to notify a tribe, and it goes to what Dr. Worrell was saying there in terms of being able to be consulted right away. Has the department responded to the concerns that have been raised by Chiniga specifically?
So I want to emphasize that the department's committed to strengthening to the maximum extent possible the requirements for consultation with Indian tribes, Alaskan Native villages, and Native Hawaiian organizations on any discovery or excavation on federal lands. The revisions to the regulations that would streamline the process and make clear what the steps are for federal agencies and federal land managers should assist both Indian tribes and federal agencies through the process. To answer your question specifically, the department does plan on publishing direct responses to all the comments that we received from Indian tribes and Native Hawaiian organizations during consultation, including those that were submitted by Chiniga. And we hope that Chiniga and other Alaska Native villages and corporations and organizations will provide additional feedback and actively participate in consultation once the proposed rule goes to publication.
Can I ask Dr. Worrell to comment on that? Because what I'm hearing here is that yes, the native village of Chiniga will be consulted, but it will be after a period of time within which, for instance, Park Service has had, they have been storing the remains or the artifacts. And so I hear what you're saying, but I want to make sure that I hear Dr. Worrell correctly too, that the concern is that there is a lag and there is discretion with the agency about when then to bring in the tribe.
My own.
There you go.
Yeah, I got it this time. Thank you, Senator. Well, I'd like to refer you to subsections 10.5 B and C. And these sections give the impression that all or most discoveries occur as a result of intentional ground disturbances. These sections must also acknowledge and consider that often discoveries result from unintentional ground disturbances caused by natural forces, storms and floods, and unanticipated outcomes of human activity. For example, cleaning out culverts or the discovery of illegal and unauthorized excavations of Indian graves. We strongly object to the removal of the requirement by the federal officials to notify and initiate consultation with any known lineal descendant and likely culturally affiliated Indian tribe or Native Hawaiian organization within 3 working days of receipt of a written confirmation of discovery. So that is our reading of it, that there is that ambiguity, and I think it needs to be clarified, and we need to, ensure that there is immediate consultation. But the section, in our opinion, gives this other impression.
Thank you for clarifying that, Dr. Worrell. I appreciate that. Mr. Chairman, I have no further questions other than to thank all of the witnesses and the contributions that they have made. Very important, and look forward to further work from the committee here.
I'm an extraordinarily lucky person, but among the ways in which I'm lucky is that as chairman, I get to work with Lisa Murkowski. So it really is a pleasure to work with you and your staff. Thank you very much. Dr. Ortiz, I'm going to have a number of questions for the record for a number of the witnesses, but I'll just flag this because I think it's really important as we consider any legislative work to do on a bipartisan basis. If you'll take this for the record, just are there any additional aspects of NAGPRA that GAO can help us to address? And if you'll take that for the record, I'd appreciate it. If there are no more questions for our witnesses, members may also submit follow-up written requests for the record, questions for the record. The hearing record will be open for 2 weeks, and I want to thank all the witnesses for their time and their testimony. This hearing is adjourned.